It gives me great pleasure in introducing Karus. Karus Prinsloo is is a manager of regulatory compliance at Inlexso, and has 10 years experience as an in-house advisor and a legal and in the compliance environment across a vast range of industries, and has also been very involved with POPIA for the last 5 years, because POPIA came into effect, I think, in 2013, and has been going for many years. But obviously, starting from the 1st of July, they've enacted a whole lot more to POPIA, and POPIA is going to really have some teeth from the 30th of June, or the 30th of June 2021. So basically 1 year to really comply with POPIA, and looking at what's just happened with Experian and what's happening with what happened with Momentum and all these data leaks, and the information regulator is starting to really going to be putting pressure on companies. So we're really happy to have Karus here today to explain to us what POPIA is all about. Karus also was admitted as an attorney in 2003, so is a very well qualified person to be talking to us today. And as I say, has been an in-house advisor, compliance consultant for many years, and been integral part of POPIA since 2013, since inception. So welcome, Karus. We're looking forward to your presentation. And great. Over to you, Karus. Thank you.
Thank you very much, Jono. Good morning, everybody. Well, firstly, a big shout out to all the women at the end of Women's Month. Thank you for all the phenomenal things that you do in the community. And well, as Jono said, with this piece of information, with this legislation that came into effect, it is something that I'm really passionate about. For me, it is about unpacking compliance requirements in an easy to understand way for our clients, and to digest information on behalf of our clients to assist them with real value adding compliance services. A bit more about the organization that I work for. I'm from Inlexso, as Jono said. We offer end-to-end legal solutions and transcription services. For a lot of clients, we're an outsourced in-house advisor. So we are either on site working for our clients as legal and compliance advisors, or we do it on an ad hoc and an outsourced way. We comprise of a team of highly specialized professionals. There are about 20 or so attorneys and advocates, and other expertise specialist consultants that work in our team. At Inlexso, we cover diverse areas of the law. For instance, on the regulatory compliance side, which is my field, and then also commercial law, mining, property, environmental, labor, health and safety, and so on. We offer services on an exclusive basis or by means of an outsourced model. So it is very important for us to have a long-term relationship with our customers. We are very proud of the long-term relationship that we have with Barnowl as well. The journey with Barnowl spans over 5 years already, and we assist customers with compliance content in the Barnowl system as well. It is very important for us to be adaptable to our client systems and processes in order to offer practical and strategic advice as you require. So in terms of today's session, on the left-hand side of the slide, we're going to unpack a bit who or what is POPIA, who is impacted, who is responsible, and how does this affect me? we're going to look at some risks and then importantly opportunities that the legislation bring. And we're going to share some lessons learned while we assisted organizations from various sectors and industries over the last 5 or so years. And then lastly, just also to mention how we can assist you in your POPIA endeavors. The purpose of the Act is to promote the protection of personal information of data subjects. You and I are data subjects. A data subject is the entity to which personal information relate. So something that's interesting in the South African context, there are very few jurisdictions where legal entities can also be data subjects. So over and above me and you being data subjects and having personal information attributed to us, it is also, in the South African context, it also happens that legal entities have personal information that is attributed to them. So the company that you work for or whatever organization, they are also attributed to this. POPIA is a very well-founded piece of legislation. It is based on international best practice. There's a lot of international privacy legislation that has been enforced for a long time. The data privacy legislation in the UK has been around for very long, and more recently, it may be that you heard of the EU GDPR, that is the General Data Protection Regulation, as it stands in the EU. Now, POPIA reflects all the best features of international privacy legislation. It's a very well-founded piece of legislation. It reflects principles that comes out of the King Report on Corporate Governance as well. And the Act accommodates international standards, such as COBIT 5 or ISO 27001, international standards like that forms the foundation of the legislation. At the heart and core of the Act, there are 8 conditions that must be complied with in order to ensure the lawful processing of personal information of data subjects. So we are going to have a look at those 8 conditions in a bit. And then importantly, where we stand in terms of the Act. As Jono said, the Act has been phased into operation. It was enacted in November 2013 already. Certain sections then came into effect in April 2014. The new information regulator, which is the regulator for enforcing this legislation. And as Jono said, this is a regulator with claws, and this Act has real teeth. The information regulator took up office in December 2016. Then regulations were published at the end of 2018. And this year, on the 1st of July, is the commencement date for the bulk of the requirements out of POPI. And there will then be a 1-year window period to comply. So in terms of timeline, it means that we currently have about 8 months or so left in order to be fully compliant with the Act. That's a tall order. In terms of international benchmarking, we've seen that it can take up to 3 years to be ready. So if your organization is not going through the motions already to ensure compliance, it's definitely now the time to do so. And we'll talk a bit more later about what it is that we should practically do. Just to lay a foundation for today's session, we're going to look at some definitions in the Act. So with this being the Protection of Personal Information Act, the reason for us referring to it as POPIA is the information regulator, refers to it as POPIA. And it's important to note that this information regulator is also responsible for enforcing the PIA Act, the Promotion of Access to Information Act. These two acts are two sides of a coin in terms of our constitutional rights. POPIA is about our constitutional right to privacy, whereas PIA is about our constitutional right to access of information. And we'll unpack some of these requirements a bit further during today's session. So in terms of the definition of personal information, it relates to information relating to an identifiable living natural person, or then, as we said a bit earlier, also to an identifiable existing juristic person. And then it's a fairly comprehensive definition. On the screen at the moment, we show the different aspects that are covered by the Act in terms of the definition of personal information. If you look at that and you apply it to your direct working environment, have a look at what of these components do you work with on a day-to-day basis. As you can see, it's very comprehensive. Again, it's because it is based on a very well-founded international precedent. We summarized the definition for you on this slide. So the bottom line is a very comprehensive definition. During sessions that we presented at Enterprises University of Pretoria, I always provide for opportunity for people to identify in the definition what is not included there. And the interesting thing is, if we look at the components of the definition, it is literally, I see physical addresses on the list, then the third column, but a postal address, an old snail mail address, does not form part of the definition of personal information. Except for that, it's very, very comprehensive. So other important definitions to take into account is the Act is about the processing of personal information. So we're going to have a quick look at what processing entails. And again, it is a comprehensive definition that includes anything that you can do with information. So as we show in red on this slide, it is about the collection or the use or the storage or the distribution or the destruction of information, which is seen as processing. So it includes everything in the information life cycle. The Act provides for specific role players, and it is necessary for us to look at the definitions of those role players. So the Act speaks about a responsible party. Now, the responsible party is the organization or the entity which determines the purpose and the means for processing of personal information. In other words, while you sit in your working environment, your employer would, for instance, be the responsible party. If you work in a HR environment, in a HR department in an organization, you process employee information on behalf of an employer, and that employer is the responsible party. The data subject, as we said a bit earlier, is the person to whom the information relates, and that can be an individual or a legal entity. What's interesting about a legal entity is, for instance, in the South African procurement processes, where we process lots of information about other entities as part of procurement process, or perhaps in the finance environment in debtors and creditors, where we process information about legal entities, about our customers, and that's information that's not available in the public domain. That would be examples of personal information that's attributed to a data subject, which is a legal entity. It's going to be very interesting to see how this is going to evolve and how this is going to be interpreted in the South African context. Then the other important party that the Act provides for is the role of the operator. Now, an operator is a person or an entity who processes information for the responsible party that we spoke about a bit earlier in terms of a contract or mandate, without the information coming under the direct authority of the operator. So, in other words, an operator is an entity that processes information on behalf of a responsible party. An example of that would, for instance, be in a call center environment. In the financial services sector, the responsible party would typically be a financial services provider, and they have call centers with outbound or inbound calls that's being handled. And such a call center would, for instance, be an operator acting on behalf of a responsible party. Then another definition is about the information officer. The information officer is a role that has been introduced by the POPIA Act that we spoke about a bit earlier. So that is the Promotion of Access to Information Act. For my sins, my journey in compliance started around the year 2000 when legislation such as POPIA and FASE and FICA and so on was introduced. And the role of the information officer is provided for originally in the POPIA legislation, and that is the person within an entity who is ultimately responsible for the processing of personal information. So in a public body, the POPIA Act and now POPIA provides for who the information officer typically is within a public body. So a public body is a state entity or a state-owned enterprise, for instance. And a private body is a entity operating in the private sector. So in the private sector, it is typically, according to the Act, it is the CEO or the equivalent officer in the juristic person, or then somebody else to whom this responsibility has been delegated. So it's important to sharpen your pencils and have a look again at who is the responsible party within your organizations, and the role of that responsible, the information officer, is now strengthened significantly by POPIA. So in terms of how the legislation works, we showed a bit earlier that the Act applies to the processing of personal information. We unpacked the three parties. There's a responsible party and the data subject and the operator. So the Act applies to the processing of personal information by a responsible party, and that is now a responsible party that's domiciled or located in South Africa, or not domiciled in South Africa, but the responsible party makes use of automated or non-automated means within the Republic. That's something that we can unpack in more detail, perhaps in a consultative relationship with yourselves. It can become quite technical. Who is who in the relationships in terms of the processing of personal information, but we always fall back on who is the responsible party, who is the operator, and who is the data subject under specific circumstances. this third bullet on the slide, POPIA trumps all. Now, if there's an important nugget to take out of today's session, it is POPIA trumps all, except if something else trumps POPIA. Now, what that means is whatever contain the strictest requirements, so whichever legislation provides for the strictest requirements for the processing of personal information will be the information that prevail. So, for instance, the Income Tax Act provides for certain retention periods. The Companies Act provides for other retention periods where POPIA are referred to retention periods. The bottom line will be whichever legislation provides for the strictest requirements, that will be the legislation that must be adhered to. So the Act provides for certain exclusions. We show all of the exclusions on the slide, but perhaps one of the most important things to take out of this slide that you can apply in your day-to-day working environment is POPIA does not apply to the processing of personal information. Then the third block that has been de-identified to the extent that it cannot be re-identified again. In other words, if I work with an Excel spreadsheet containing, let's say this is now in a customer-facing environment, containing customer information. If the customer information in a list has been de-identified to the extent that it cannot be re-identified, then the Act would not apply. In other words, if we can strip out any unique identifiers, name, surname, telephone number, ID number, and we use that information in such a de-identified way, then the Act wouldn't apply to that. So perhaps, for instance, in the IT environment, when you provide for testing data, if the data that you use has been de-identified to the extent that it cannot be re-identified again, then the Act would not apply. The Act also provides for the rights of data subjects. There's a list of rights of data subjects, and these are important and sound rights. It is about my right as a data subject and the protection of my personal information. So it's, for instance, about the access right and the right to protection of information and so on. We aren't going to go into detail in that during today's session just because of time constraint, but take note, the Act provides for very healthy rights of data subjects. And it's a good thing, again, if you put your hat on as a data subject, it is about your rights to your personal information. Then the Act also provides for the conditions for the lawful processing of personal information, and that is, so we'll unpack those 8 conditions just now, but it is about a data subject's personal information that must not be interfered with. And in terms of the Act, if there is interference, then the aggrieved party may lay a complaint with the regulator. And it's interesting, a negotiated settlement is one of the potential outcomes of a complaints procedure. So, in other words, the Act brings interesting remedies as well, but we'll look at that in a bit more detail in a while. As we said, at the heart of the Act, there are 8 conditions for the processing of personal information, and those are displayed on the slide at the moment. So it is about the accountability. Accountability speaks to the other 7 conditions, and serves as an introduction to the other 7. The second condition is about processing limitations. It's about the type of limitations that apply to the processing of personal information. Then the third one is about purpose specification. If we could perhaps highlight, for purposes of today's session, condition number 3, 4, and 5, and on the others we're just going to touch. So in terms of condition number 3, purpose specification, it is necessary for us to be in a position to answer why. Why is it necessary to process this information? I see on a very frequent basis forms, application forms, CRM type forms that provide for date of birth and for ID number. If it's not necessary to cover both those fields, let's not process it, because at the end of the day, whatever we process, we must be in a position to justify why do we process that information. And then in terms of the other side of the coin, in terms of the POPIA Act, Promotion of Access to Information Act, I've seen examples where in terms of POPIA, where it provides for a process that can be followed in order to access information. So the information officer within an entity receives an access request from an individual or another or a party, and POPIA provides for a mechanism to access information. Now, if you don't need certain pieces of information anymore, then rather don't have it anymore, because from a organizational risk perspective, I've seen examples where one of our clients, for instance, still had employee records going back to more than 50 years. No, let's not use employee records as an example. There were information available that was still in archive that's more than 50 years old. Now, because of the POPIA process, it is possible to ask to access that information. And this specific organization lost more than a week's worth of operational time to locate that specific piece of information which related to the access request. So, in short, if it's not necessary to process certain information, just don't carry it. And it's necessary to test ourselves on that on a frequent basis. Then the fourth condition relates to further processing limitations. It is important that in terms of this condition, any further processing must be compatible with the initial processing of personal information. So, for instance, in a marketing environment, some time ago, in the old days before lockdown, when I was walking in a mall, in a shopping mall, there were marketing representatives dressed like flight attendants that came up to me, and they asked for my name and surname and cell phone number. It was done in a cute way. It almost looked like a flight ticket on which they enter this information, and that is then to go into a lucky draw in order to win national flights. Now, in terms of further processing, if that information is originally collected for purposes of a specific competition, if it is going to be processed later for another reason, that other reason must align with the first reason for processing the personal information. So it's going to be necessary for us to look at existing processes, business processes, and the impact of the Act on your existing business processes. So another example of this is during a public session that we conducted on POPIA, there was an attendee from a broker, a financial services broker's office. And when I spoke to them about security safeguards, so that's now condition number 7 there on the right-hand side of the slide. Security safeguards means it is necessary for us to take reasonably expected steps. So it's the legal reasonable man test that comes into play there, but to secure the information that we process. That's also where the data breaches comes into play, such as the ones that Jono referred to during the introduction. So with the recent Experian data, the information that were exposed, it is about what security safeguards did the organization have in place in terms of POPIA to ensure that this doesn't happen. Now, in terms of that example of the broker, I'm from Pretoria, and here's a residential estate close by where an employee of this financial services broker during a session told me that in the old days, prior to when they scanned license discs and your ID license card when you want to access a certain premises, they used to have these manual books where you entered your name and surname and cell number and ID number and so on. So in terms of purpose specification, the reason for that is to be in a position to contact the individual that is accessing the premises. So in your work environment, when that type of information is requested at your reception, the purpose specification is again most probably from a occupational health and safety perspective, to know who is in the building if it's necessary to contact them. Now, in terms of security safeguards, this broker's administrative staff member told me that they bought those access registers that was used at the residential estate for when people accessed the estate, and that is where they emanated leads from. So they used those telephone numbers and names and email addresses to contact potential clients. Now, in terms of security safeguards, that's just not on. Another interesting thing is you would have seen in the past that at the bottom of marketing SMSs, it always said please reply with stop or opt out in order to opt out of the marketing process. Now, interestingly, POPIA now provides for opting in. So it's going to be necessary for you to be very strategic about when you are going to ask your customers to opt in for marketing, because in terms of the legislation, you also just have one opportunity to do that. So another interesting thing that the Act brings into play is opting in compared to opting out the way it used to be. And then lastly, in terms of the 8 conditions, it provides for data subject participation, as you can see there in the 8th condition there on the right-hand side. Now, at the bottom of this slide, information that is already available in the public domain or that is enforced by legislation falls out of scope of the Act. What we mean with that is Also in terms of POPIA trumps all, except if something else trumps POPIA. For instance, demographical information of employees that's being processed. An employee wouldn't have a foot to stand on to say, no, employer, don't process my demographical information, because it is enforced by another piece of legislation. The Employment Equity Act enforces the fact that demographical information should be processed. Then also what we say there at the bottom of the slide is information in the public domain. So any information that you in your personal capacity already put out in the public domain, for instance, via social media, Facebook or LinkedIn, that means it's available in the public domain and it falls outside of the scope of the POPIA Act. I've learned a very important lesson with this slide, the importance of the letter L. If you see there at the bottom, information in the public domain, I presented this slide numerous times before I realized previously that with spell check and so on, I left out the letter L. So I'll always remember the importance of the letter L. Now, in terms of special conditions, there are stricter rules that come into play when we process personal information relating to the categories that's currently on the screen. So it's necessary to take into account whenever you process personal information of children under the age of 18, there are stricter rules that come into play and stricter ways in which the consent would work that must be provided if it is necessary for consent under those circumstances. So take note of what is listed on this slide and remember in future that it's necessary to apply stricter measures when processing this. So for instance, there with the fourth block, when it is personal information about health, sexual life, or biometric details, there are more stringent requirements that come into play, which is very relevant at the moment with the COVID-19 arrangements, and it is necessary to take these processing limitations in terms of the special conditions into account. The last block on this slide, talking about the transfer across South African borders, is again just about the take into account that when you transfer information across South African borders, there are also more stringent requirements that come into play. And here in a cloud environment, we frequently get the question about where are the servers physically located, and yes, that comes into play with POPIA because it is about the different jurisdictions as well. So as we said a bit earlier, POPIA trumps all except if something else trumps POPIA. And in other words, if the receiving jurisdiction have stricter rules than ourselves, then their stricter rules would apply, and then it's okay from a POPIA perspective. There are also specific circumstances when it may be necessary to obtain the information regulators go-ahead before transmitting certain information over borders. So take note, there are 8 conditions, and then there are special conditions that also come into play. So when we talk about the jurisdictional aspects, on this slide we just show under which circumstances information may be transferred to another country. Without further ado, in terms of the practical implications and consequences of non-compliance. Now, this is an act with real teeth, and it has vast impact on business in general. On the left-hand side of this slide, the type of business processes and information systems impacted by the legislation is wherever there is customer interaction. There's a lot of personal information being processed. From an HR perspective, the type of employee information that we process, and for instance, payroll information. On the procurement side, as we said a bit earlier, in terms of the definitions of a data subject, a legal entity can also have personal information attributed to it, and therefore it's important to also take POPIA into account in the procurement space. Definitely, the Act has a great impact on information management or on IT. Then, from a marketing perspective, we referred a bit earlier to opting in and opting out, and yes, the rules of contact has changed significantly by POPIA. And then lastly, as we said a bit earlier, the international transfer of information. There's also an impact on our business processes and information systems from that perspective. Now, this is an act with real teeth and claws. It brings a huge reputational risk, as we have seen with the recent examples in the South African media and also similarly internationally. We really don't want to be the organization that's named and shamed and whose name is published on the front pages of newspapers because of security breaches and so on. The Act provides for a unique way to deal with contraventions in that the negotiated settlement is one of the outcomes. So an aggrieved party can lay a complaint, and the information regulator will serve as an arbiter, and a negotiated settlement can flow out of that. For administrative fines that the information regulator enforce, it's not necessary for a court order to enforce that. The Act also provides for civil remedies. In other words, as a data subject, you can also sue civilly. You can sue a party that treated your personal information in contravention with the law. Then where it shows the real claws and teeth of the Act provides for 10 years imprisonment and for administrative fines of up to 10 million rand. Now, we see in terms of international benchmarking, further versions of, or more recent versions of privacy legislation provides for percentage of turnover, such as we see, for instance, with the GDPR. So, yes, take note. This is an Act with real teeth. Just to unpack those business areas impacted by the Act a bit further, as you can see on this slide, it really have a big impact on your systems and business processes. And we've just listed some of the areas in your business that is affected by POPIA on this slide. So practical implications of POPIA, well, it includes the strengthening of the role of the information officer, as we said a bit earlier. So this is that role that has been introduced by POPIA previously. It is necessary to identify those three parties, who is the responsible party, who's an operator, and who's a data subject. It is necessary for us to ensure that our business processes are aligned with the Act's requirements. We can conduct a risk assessment of our security safeguards and remedy our weaknesses. And it's going to be necessary to amend your POPIA manual in accordance with the Act's requirements. So how do we go by to mitigate our risks? It is necessary for you to establish what is the impact of the Act on your business, and that is, for instance, done by conducting a gap analysis. So a gap analysis is just a comparison between the as is and the to be in your organization. So it is necessary to establish what is the impact of the act on your organization. Then another quick win is to obtain consent to process under certain circumstances. It is necessary to amend existing business policies for the processing of personal information, to relook your access rights, who has access to what information. Device security also comes into play, especially now during the COVID times as well, where it's to be differently enforced than before. So device security is very important. It may be that it's necessary for you to include certain standard clauses in agreements going forward. It's definitely going to be necessary to train your staff, and then it's important to look at the opportunities as well. So compliance is not just about a stick. It's not just about those impact or those potential financial or reputational risks for the organization, but the legislation also brings great new opportunities. So in the first place, it is possible for you to show from a reputational perspective that you're a responsible corporate citizen and a data subject's personal information is safe with you. It's necessary for you to go and identify in your direct business area which opportunities could present itself. About 5 years or so ago, I had a quick conversation with a very, very assertive MD of a entrepreneurial organization. I had a very short time to talk to him about compliance in general, and the moment when I asked him about POPIA and their organization's perspective on POPIA, he almost took a negative stance, and he said, no, you see, that's again a hurdle that's being put in place of business. It's so difficult to operate in this country with all these regulatory hurdles in the way. Now, about 6 months or so later, I met his successor, and when I spoke to him about POPIA, his face lit up. He said it's the best thing that happened to their business, because they're a player in the stationery industry, and they've been selling shredders, so to shred hard copies of documents, to shred paper at a rate that shot the lights out for them. So legislation brings opportunity, and it's necessary for you to identify those opportunities in your environment. There's an opportunity for you to contribute to the code of conduct for an industry. The Act provides for a code of conduct that could be prepared, and then the information regulator approves that code of conduct. And this legislation provides for opportunity for you to strengthen your governance structures. It also brings technological opportunities. It may very well be that certain processes that you've done in a manual fashion in the past can now be done in an automated way. So in the past, over the past few years, we've assisted customers with their readiness endeavors, and that would typically be done by doing a gap analysis. A lot of organizations will do this themselves, and we will gladly also assist you in your endeavors here. So we've worked in industries such as retail and construction and tertiary education and manufacturing in terms of gap analysis. That's basically about a organization-wide analysis of the state of processing of personal information to identify the affected areas of the business. So for instance, on the customer side, your CRM systems, HR, marketing, advertising, and so on, to identify those areas, then to get representatives of those areas on a project committee. So, and to use your own organization's project governance methodology. So what would typically happen during a gap analysis are the steps that we show on the screen now. And it's ultimately about getting to that last block, to formulate a project plan, which contains the action points that we need to deliver in order to be POPIA compliant. So that's then the action plan, and that needs to be implemented by the end of June of 2021. So we are looking at very, very short timelines to work on this. Then a few lessons that we've learned in terms of what not to do when it comes to POPIA projects. Sort out the ownership. Who should be responsible for driving your POPIA readiness initiative? It is not IT's problem, and it's not compliance's problem, and it's not legal's problem. Compliance is everybody's responsibility. So identify in your organization which functions should drive the process. Then remember the two sides of the coin. While you're working with POPIA readiness, also look at your POPIA processes. It's important to follow a phased approach. So first to identify and then to implement. It's about that action plan, getting to the actions and then to implement those. And again, it's against very tight timelines that you're going to work with that. It's important to take note that it is wider than just the 8 conditions. So take special personal information, the requirements relating to special personal information, international transfer of information into account. And then we've developed a unique method at one of our clients where we used an information asset register to identify information flows. So in other words, in which department, in which area of the business in an organization is what information processed? What is the reason for that processing? Who is responsible for what? So we have physical asset registers in organizations where the assets are mapped, and to similarly map out an information asset register. That could be one way in which you could provide for POPIA in your organization. So then in closure, we have another 5 minutes or so left. We'll quickly address some questions, but in terms of the way forward, if you haven't done so already, it is necessary to work with the action plans to be compliant with this legislation by the end of June of 2021. That's a very short timeline. Identify the actions that you need to take as soon as possible so that you can implement, so that you can be ready for the end of the window period at the end of June of next year. The barn owl methodology also provides for action plans. So action plans could be one way of managing what must be done by whom and at what stage. Then over to Cheryl and Jono, if there are any questions to handle live. Thank you very much, Cheryl. Thank you very much, Jono.
Thank you very much, Karus. I think that was very informative. And thank you very much for your time. So I think the best way is to handle people putting their hands up and then to unmute yourself and ask Karus a question. Ronel. You just need to unmute yourself.
Sorry. Ronel
Okay.
Pritje, JVC Insurance Brokers. Karus, thank you. Very informative session. Is it at all possible that you can send me the recording of the session?
100%, Ronel. The recording will be available, I think, on Barnell's website. So, Jono, if I can perhaps ask you and Cheryl, it's going to be available on the website, right?
Yes, that's right. We'll do a write-up, and the slides will also be available. So, thank you.
Thank you.
Thanks for the question, Ronel.
Thank you.
I'm not sure who's next. Sorry, I think just is that Makwena? Not sure.
Hi, Jonathan. Yes, it's Makwena. Thank you so much. Thank you, Karus, for a fruitful insight. I was actually, as I was listening to you, thinking that maybe I'm from compliance. So maybe I was thinking it could be legal, it could be IT, that could actually be the custodians of the legislation. But as you were going through the slides, you made mention of the fact that we kind of need to leave them alone, for lack of a better word. But now my concern is who then in the organization, because it's cutting across so many units, who then would be recommended to be the custodian of this legislation?
Makwena, I think, sorry, it's Makwena, right?
Yes, that's Makwena.
Makwena, thank you very much for your question. There isn't a one-size-fits-all answer for that question. And unfortunately, with most of the POPIA related implementation plans, unfortunately, it's not a one-size-fits-all approach. But yes, it's unique for every organization. But what we've seen is that the information officer in terms of PIA and POPIA will play a very important role in terms of your project. If you work for an organization where there is a project office type business unit or organization-wide functionality, it is great if a organization-wide project can be driven from a function like that. But Makwena, the short answer is it's important to get the highest strategic buy-in into the project. It is necessary to then get the necessary governance, project governance mechanisms in place according to your organization's fit. And it could be that in a specific organization, legal or IT or the company secretary or the FD plays a pivotal role. But who is ultimately responsible for the whole of the project is something that differs from organization to organization. It could be any of those areas that we spoke about, Makwena. The most important thing is to accommodate different areas from the business in your POPIA readiness endeavors in your team. Thank you very much, Makwena.
Karus, another question from Joseph. Joseph has got his hand up. If you just unmute, thank you.
Yes, thank you. Thank you for the good presentation. I may have joined the meeting late or have missed certain parts on the presentation. That's a good presentation. Thank you so much. I just want to find out, please, does the legislation allow us to save data out of the borders of SA? For instance, we in our environment wants to go Office 365 and some of the servers are situated out of the borders of SA. So I need to know, in that case, how do we deal with it? Or is it a matter of us still saving data out of the borders of SA, like OneDrive, for instance, or even Microsoft Teams as well? But as long as we can prove and give evidence that our data, is secured, and we have these strict policies in place that can secure that data. Is that allowed?
Thank you very much, Joseph. It's a very relevant question. So what we see in practice is the legal departments ask the questions about where are the servers physically located. If a server is located, I think, for instance, Microsoft servers have a presence in the Netherlands and in Ireland. So when the servers are located in jurisdictions that have strict measures in terms of their privacy legislation, it helps a great deal. So luckily, most of the well-known service providers, it's very important for them to subscribe to the strictest of rules in order to give their customers assurance as well. So whenever you work through agreements, yes, it's necessary to check which locations, which jurisdictions data will be moving towards. But the good news is when you look at those bigger players in the market, there's been a lot of pressure on them from industry internationally, for instance, with the GDPR, to ensure that there's adequate protection. It may very well be that we're going to see, I'm speculating, but it may be that we're going to see a much bigger presence in South Africa as well. So, quick answer to your question, yes, it is relevant. Where do we move information to? Yes, the Act regulates that. And ask the questions to your service providers. It is necessary for them to give you assurance about security and about where information is processed to.
Thanks, Karus. There's a question from Jackie. Jackie's on screen.
Hi.
Hi, Jackie.
Thanks for the wonderful presentation. I'm from the public sector, and what I just wanted to find out, how will the annual report and the integrated annual reports, how will this affect it in terms of, there's lots of personal information like, directors' remuneration and bonuses and even your race and all that type of information is disclosed. Is that going to have an impact on the way we start producing our annual reports? Thank you.
Thank you very much, Jackie. So when we spoke about POPIA trumping all except if something else trumps POPIA, in the private sector environment, it's, for instance, the Companies Act that drives certain disclosures that must be made. I think in the public sector, it might be the PF, in terms of the PFMA, for instance, or on municipal level in terms of the MFMA. So the short answer is it's still going to be possible for us to process the information that we do process. When we're confronted about questions about purpose specification, when a director asks you, so why is my information disclosed in the annual report? The answer is because it is required in terms of other legislation. Jackie, your question has a lot around a lot of flesh around it, but I tried to give a very concise answer to that. You are also very welcome to contact me going forward, and we can unpack it a bit further.
Thanks. Sorry. Thanks, Karus. There's a question from Muzi.
Yes, morning, colleagues, and thanks for the presentation. It's quite informative. Mr. Menyar Prinsloo, you make mention that organization needs to, as part of the building up the compliance to POPIA Act, they need to start having a project plan and so forth. So I wanted to check, is the one size fit all in terms of the activities in the project plan? Do they vary? Will they vary from organization to organization? What I'm trying to say, is there a template for such, and maybe if you can share some more light in terms of what will be those obvious checkbox that should be part of the activities as we try to move towards compliance as organizations.
Muzi, thank you very much. Over time, we've identified certain themes that we see coming out that needs to be addressed as part of POPIA readiness. We haven't published specific documents on that yet, but yes, it is possible to identify certain themes that must be addressed, and I'll gladly share offline with you some insights in that regard. I hope that going forward, it would be possible to assist with a methodology of sharing certain themes that has to be addressed within most organizations, and then that one can customize that for your own organization. It's definitely something that I'd like to discuss further with you, Muzi.
All right, thanks.
Thanks, Karus. We have Mampiko had an interesting question earlier on, so please ask your question, Mampiko.
Hi, thanks for the opportunity, Jonathan. Thanks, Karus. It's been quite an interesting session. I have a new one, in fact. So that one still remains, and that question related to how the fines are allocated at times. So is it an aggregate allocation, or is it per record breach? I think that's quite important for organizations to understand in terms of sizing the risk of data loss and breach. The other question I had is a follow-up on the question that Joseph had earlier, and it relates specifically to what stance or what is your opinion on American vendors, American storage, and here, I mean, I'm not talking about the larger providers like your AWSs and your Microsofts, which do have, there's always an option in a GDPR jurisdiction. I'm talking specifically around your smaller players where data is stored in the US, because for me, it's always a big debate. For me, the risk has always been that, or the discomfort has always been that, although the California state law exists, with American law, there's always federal law that you need to worry about, and federal law trumps state law. And then there's the recent, I can't quite remember the detail, but there's been a recent ruling regarding the privacy shield, which was previously used by many as a defense mechanism to say if the company subscribed to the privacy shield, then it was deemed to be safe harbor, so to speak. So I'd just like to get your opinion on that as from a jurisdiction perspective and data sharing.
Thanks, Mampiko. Your questions are a mouthful, and I'm only going to touch on some aspects of it. Let's look into the second question first, about the US jurisdictions. Yes, the interesting thing is with a federal setup in the states, it is necessary to look at the the law in the specific state as well. So it's definitely necessary to use that cascade that you were referring to look at the local law, then look at the federal law as well. I'm aware of it that in California, specifically, there's a new piece of legislation being introduced at the moment that speaks to privacy, and that's music to my ears, because this is a big generalization, but generally speaking, it's a bit more complicated for me the moment when we speak about the American jurisdictions, because it is necessary to go and look at the law of the specific state. So the optimist in me says, due to pressure from industry, even in the American, where it's an American service provider, hopefully there's going to be enough pressure from the ultimate customers that there must be adequate security measures in place. That this thing is going to evolve to the point where some time from now we can say, oh yes, but although this isn't one of the big brands, due to pressure from the ultimate data subjects and due to privacy concerns, these things are also put out. I agree with the chain that you go through there. That's also the approach that we follow when we're confronted with questions about that. About the privacy shield, unfortunately, I'm not in a position to address that during this session. So apology for that. But then your question about the aggregate fines. The message that we receive from the information regulator is that they are very strict about the fact that POPIA has been around since 2013. It is necessary for us to know we need to comply. And the Act even builds in this a grace period of a year. So it sounds to me as if the information regulator could take the stance that we've had enough opportunity to get our ducks in a row. So that's firstly one principle. Then about how it will be enforced in terms of aggregation of fines and so on. We don't know yet. I don't know offhand, but I think what I read between the lines is that this regulator might guide us in the process rather than just smacking us with a fine. Perhaps it might be worthwhile to look at our approach in how we interact with the regulator. Perhaps it's a good thing to engage with the regulator and for us to have a open relationship with the regulator. And then when something happens, at least the regulator is aware of us. So I read in the media reports with this recent experience thing, the regulator, my interpretation is that the regulator was almost agitated by only being involved at a very, very late stage after this breach occurred. So what I read in the media is the regulator was approached for an urgent meeting. They made themselves available on an urgent basis, literally the day after this request was made, and then when they met on this urgent basis, they heard about a breach that happened months ago already, and I think it's going to be necessary for us to look at the way in which we strategically engage with the regulator as well. It is interesting where the GDPR provides for a timeline within which a data breach must, for instance, be reported. POPIA says within a reasonable time. So yes, reasonability will also come into play. With aggregation, from informal discussions with role players at the regulator, it sounded to me as if definitely when it's possible to identify a trend in terms of the way in which a specific responsible party process information, or rather if they don't process it in a diligent way, if a pattern can be identified, I think the regulator is going to look with a sharper lens at that. So in terms of administrative fines, the Act says the regulator can issue administrative fines of up to 10 million rand. I can imagine that it might be that those are fines that could be aggregated, and a total fine of X amount could be levied. But we'll have to see how that is going to pan out in practice. Mampiko, I hope I addressed some of the components of your questions. Is that okay?
That's fine. Thank you.
Thank you, Karus. I'm not sure. Thanks, Karus. I'm going to take one or two more questions. I'm not sure, Mpo, you're on screen. I'm not sure if you're aware of that. Do you have a question at all or not? No? Okay, Joseph, you're going to take one last question. Joseph, would you like to go ahead, please?
Yes, absolutely. Thank you so much. I think my last question is, I just want to know how much time do we have left to be compliant? You know, are we currently now on a grace period up until a certain time, and you know, so that at least we plan. So yeah, just in general, how much time are we left with to be compliant?
Thanks, Joseph. So the commencement date of the requirements of POPIA was on the 1st of July of this year, and the Act provides for a 12-month grace period from the 1st of July. So the expectation in industry is that by the 30th of June of next year, we need to be compliant. Joseph, this has a lot of dimensions to it, because depending on the type of organization that we work for, it may be a heck of a lot of things that we need to do in order to comply. I think it's important, and this is just me speaking, this isn't a professional opinion or anything. I think it is, in my view, one should get to the point as soon as possible where you can have an action plan, where you have identified what must be done and allocate responsibility and time to those actions, so that by the end of June 2021, we can comply. Now, that's a short timeline, but I think perhaps reasonability will also come into play. If we were to engage with a regulator and say, We've identified these actions that must be taken, and if we were in a position where we can't make it in time, perhaps it's something where you can engage the regulator and ask them. But the important thing to note is it's 5 minutes to midnight now. By the 20th of June 2021, we need to comply in terms of what the Act says. The Act does provide for the potential of an extension of the window period. I don't think we should bargain on that. As I've heard in the past that the regulator says, hey, but industry, you've known about this Act since 2013, and you knew that there's going to be a 1-year grace period. You had enough time. So I think it is important to get to that point where one can have the implementation plan as soon as possible, so that we can do as much as possible in terms of our journey to compliance. It is interesting when we look at international standards. COVID-5, we are always there on a journey towards meeting the standard. Whereas this is now legislation, and it is required of us to do certain things in order to comply. It will be interesting to see what the nuances are going to be, what will be tolerated and what not. But from a risk management perspective, identify the highest risk areas in your organization, perhaps take a risk-based approach, prioritize those big ticket items, do that first, and manage the process in such a way that you can that you'll be in a position to justify why you aren't compliant by the end of the grace period. I hope that addressed your question.
Indeed. Thank you, Karus.
It's a pleasure.
All right. Thank you, Karus. Thank you very much for your time today. As I mentioned, we will make the recording available on the Barnard website, and we will also be sending out an email, our newsletter as well. We're probably going to have to learn how to become POPI compliant as well with that. But thank you very much for your time today, Karus. I think it's been very well. We had about 170 people that joined at one stage. And I'd really like to thank the audience as well for joining, and hopefully you got some value out of it, and have a wonderful day and a great weekend, and summer's on its way. Thank you, everyone.
Thank you for the opportunity, everyone.